And speaking of our system here, I've got great panelists to talk about this case and others. Right next to me here is Doug Burns, former federal prosecutor, and Tom Kneff, former prosecutor and defense attorney, and Dan Shore, Inspector General in Yonkers and New York, former criminal prosecutor. So, oh my gosh, we've got former prosecutors there.
To go around.
Really, looking at that interview, hearing it last night, would you ever have advised a client? I know you were all, we're all some of the same ilk, we're all prosecutors. But from a defense perspective, a prosecutor, I'm loving that. I've got that now. I've got those statements. I'm going to bring those in.
Those are all admissions, as you know.
Absolutely.
No, it's hard to figure out what the motive was, other than to maybe somehow stop the bleeding in the court of public opinion. But I mean, even assuming what he's saying is true, that this didn't amount to full-blown rape. I mean, you're admitting that horseplay in a shower with a naked 8, 10-year-old.
Right.
That in and of itself, I mean, we could break out the penal code right now and start naming all the offenses.
And I'm so sorry, I forgot to introduce Sari Azari as well. Sari, are you there?
Yes, Sarah. Good afternoon.
I'm sorry, Sarah. So what do you think about this? Would you have ever let a client, or wouldn't you just be thrilled as a prosecutor that this has happened and now you can use this as an admission?
Never. I mean, you never, as a defense attorney, you never let your client speak. No good can possibly come out of that, unless it's a situation where they're before a grand jury and they've got immunity, which is not the case here. This was probably the biggest mistake, and it often happens in a lot of these high-profile cases. I can't get my head wrapped up around it, so I would have never allowed my client or Sanduskys to speak. But I think there's another issue here too with the conflict of interest that's raised about the judge. And I think that, that's a whole other ball game that throws a twist into this case, and whether this judge can actually be fair and impartial in this case, given that she's volunteered for an organization that Sanduskys founded in the 70s. So this is definitely a very interesting case that as it unfolds.
And just to back up, Sarah, that the judge released Sanduskys on, I think it was $100,000 bail. And you're shaking your head saying, was that wrong? Was that the wrong thing to do?
Bail.
What do you think, Doug?
It seemed a little bit low, yes.
It seems low. It seems like a very strong case, and that's one of the factors you consider with bail. Is this a strong case? Is the person likely to be in prison for a long period of time? In addition to the fact that he went on TV, which was really strange, he didn't seem prepared for questions. He did it by phone, which made him sound even more distant. I mean, of course, we don't have sympathy for him because there's overwhelming evidence that he's a child sex offender, but it was bizarre. I followed a lot of cases, as have everyone here.
Sure.
I don't think I've ever seen a defendant just call into a show and expose himself like that early in a criminal prosecution.
Do you think the lawyer was behind this or not?
Also, Liz, I mean, look, quick cross-reference to another case. We just saw Dr. Murray get remanded, after that trial. And now you say, wait a second, and this guy walks out with an unsecured bail. 2 prongs. Risk of flight, I'm willing to say he's not necessarily a risk of flight. But what about danger to other kids? I mean, I thought it was too low to bail.
Right, it's predatory. I mean, it's true. It's predatory behavior at its
and it's all alleged.
Depending.
Obviously, he's
right. Of course, he's
proven guilty.
Well, that's why.
But we do wonder about. I mean, $100,000 is a lot, but it was unsecured, as you point out. So that he really he's nothing. Sarah, you were about to say something?
Yeah, I mean, it's unsecured, and the prosecutors were asking for a $500,000 bond.
Right.
So, I think that if Judge Dutchcott had sort of set bail somewhere in the middle of the road, maybe it wouldn't raise eyebrows as it did. But a $100,000 unsecured bond in my jurisdiction, that's the equivalent of releasing a defendant on his own recognizance. I mean, this man is never going to pay a penny unless he skips, and I don't think that this is sufficient considering the multitude of victims, the duration that these crimes apparently occurred in, a span of 15 years, all unreported. This is a pretty egregious offense, and a $100,000 bond unsecured is nothing.
Right.
But I think you also have to look at this judge's involvement with this organization. I mean, was she volunteering at a Sunday bake sale, or was she having regular luncheons with Sanduskys?
Yeah,
what kind of familiarity did she have?
But to be fair to the organization, we don't know that, and you're shaking your head, that anybody else was involved. I mean, assuming that, take the allegations at their face and that they're true.
I mean,
but we don't know that anyone else was involved in that.
Yeah, I mean, I'd have to temper it by saying, you got to be careful with saying that the judge, factored in this relationship in her bail decision. That's a pretty serious accusation.
Correct.
So let's take our time with that one.
Correct.